Hello, students. In today's lecture, we are going to study labor legislation in India. That means labor laws. This is a content of Unit 1, Employment Law in India and United States. So, a law legislation means law itself. It is also called as law. So, law related to workforce management, employment, trade unions, and they are together called as labor laws or employment law, and they fall within the broad category of industrial laws. Okay, so whatever laws are concerned about trade unions or employment, they come into category of employment law and industrial laws. Okay, so which law is considered to be a good law, or which law is you know uh, how I mean good labor laws which protect the rights of workers is considered to be the indicator of modern nation. So, when we say that this particular country is a modern country, it means it is a country having laws which protect the rights of workers and employers. Okay, and you are building a good society in your country. So that's the indicator of modern nation. Then these labor or employment laws came into existence because of the demand of employees to have better working conditions, and demand for employers as well for a good organized power of workers, and to have certain flexibility to run the organization. Okay, so the demand of both the aspects of organization, that is employers and employees, these laws came into existence. As far as we are talking about labor laws in India now, so these laws were definitely being influenced by British laws, because we were under British rule for 150 years. So our laws also have that influence. Our education system do have their influence. So naturally, our laws also do have. Then yeah, the British had enacted so many laws to protect their business interest. Now, but and, as per the political and social thinking in the country, the laws were passed according to that. And the Trade Dispute Act 1929 was one of the earliest law in industrial laws affecting the employment and employment relations in India. After that, when we became independent in 1947, many laws were passed and amended and introduced to meet the changing requirement and political reality, because there was a drastic change after independence, and so according to as per our need, we made certain changes in the laws. Okay, so the Constitution of India is source of all the laws, and therefore we have set a basic framework for Indian labor laws. Okay, so um, this is what the background of labor legislation in India we are having. Okay, so going towards articles affecting government employment. Okay, so which are the articles which have considered the while drafting the labor laws for government employees especially. So government is employee, or a government is the largest formal sector employers in India, and government job cannot be classified along the type of the work done in private organization, and constitution has laid down separate provisions related to government employees, means both for central and state government. So law has been made and provisions have been made both for central and state government separately. Now, which articles in the laws deal with these people is that Article 309 is an article which deals with recruitment and conditions of service of people employed by government, and Article 310 gives information about the tenure of persons holding office. Okay, how much period a person can remain in the office. And Article 311 refers to removal, demotion and dismissal of government employees. So three main parts, these articles are divided into three main parts: 309, 310 and 311. These are the articles in government law which are related to the government employees of central and state. Okay, this is the only content of articles affecting government employment. Okay, now moving towards the second point, labor jurisdiction for central and state government. Then Article 246 and 7th Schedule of Constitution of India specify the distribution of legislative between central and state government, and they have divided the responsibilities into three groups: union, state, and concurrent list. Okay, so the labor is placed in the concurrent list category, where both central and state governments are competent to enact the legislation, and some matters are reserved for central government for enactment of legislation. Okay, then next one is features of labor legislation. Mm, Indian labor law, every legislation that is an act has been enacted to serve a specific objectives. Okay, so judgments by various courts in India have given certain clarification and revisions from time to time. Okay, so objective of each act, that is legislation, is specified in legislation under the heading prefatory note or statement of objective and reasons. Okay, then laws related to industrial relationship. Maintaining smooth relation between management and labor has been always a main objective of Indian industrial relations, and all those laws falling under this category, mainly regulative in nature, they tell us about what are the do's and don'ts, काय केलं पाहिजे आणि काय नाही केलं पाहिजे, अशा टाईपचे ते लॉ आहेत इंडस्ट्रियल रिलेशनशिपच्या बद्दल. ह्याच्यामध्ये तुमच्या ट्रेड युनियन ॲक्ट 1926 प्रामुख्याने येतो, विच हॅज अलाउड फ्रीडम फॉर एनी 7 एम्प्लॉईज टू अप्लाय टू रजिस्टर अ ट्रेड युनियन. ओके, सो त्यातल्या गोष्टी किंवा लॉज रिलेटेड टू वेजेस असेल, पेमेंट ऑफ वेजेस आहे, मिनिमम वेजेस ॲक्ट, लॉज रिलेटेड टू वर्किंग आवर्स, किती फॅक्टरीज ॲक्ट 1948, शॉप अँड कमर्शियल एस्टॅब्लिशमेंट ॲक्ट 1961, या सगळे ॲक्ट ह्या लॉज रिलेटेड टू इंडस्ट्रियल रिलेशनशिपच्या अंडर आपल्या येतात. ओके, आणि त्याच्यानंतर लास्ट पॉईंट येतो तो ॲप्लिकॅबिलिटी ऑफ लेबर लॉज टू आय टी सेक्टर. आय टी सेक्टरसाठी वेगळे लॉज केलेले आहेत, बिकॉज आय टी सेक्टर वॉज इमर्जिंग sector discipline. Earlier, whenever the laws were enacted after independence, IT was not a sector that time which was emerged, and therefore separate laws are made, and they are covered under Shops and Commercial Establishment Act of 1961. So the act deal with work hours, time rate, employment of women, young persons, so different aspects are included in these IT laws. Many states have come up with some specific special act that are more suited to the requirement of the state, and many states have granted exemptions for IT companies from many critical aspects of labor legislations. So mm, for IT sector, the labor laws are totally different. So this is what is included only. We have just an introductory part. Deeply, we are not going to learn laws as such. Okay, so for today's lecture, or whatever lecture I'm giving on the whatever the syllabus is covered, I'll be giving you PDF of those notes. That would be easy for you to understand the things. Okay, so with this I end with today's lecture. Thank you.